Before we begin, a quick and important disclaimer. The historical analysis, societal overviews, and legal discussions presented in this video regarding divorce in the 1960s and its modern implications are strictly for educational and entertainment purposes only. Family law varies drastically by jurisdiction and changes continuously. Nothing in this presentation constitutes professional legal advice, financial counseling, or a substitute for consulting with a licensed attorney in your specific state or country. Historical trends and past legislative case studies do not dictate specific future legal outcomes. If you are currently navigating a divorce, separation, or family law matter, it is critical that you conduct your own due diligence and retain qualified legal counsel to understand your specific rights and obligations under current laws. Imagine walking into a dimly lit Manhattan hotel room in the winter of 1962. You are a relatively successful corporate executive, a pillar of your local suburban community, but right now you are sweating profusely through your tailored suit. You are not alone in this room. Beside you sits a woman you met only an hour ago, hired specifically and exclusively for this precise moment. You are both fully clothed, but you hurriedly unbutton your collar, loosen your tie, and intentionally mess up your hair. Suddenly, the hotel room door bursts open with a violent crash. Flashbulbs blind you in rapid succession. A private investigator and a hired photographer aggressively document the scene before you can even stand up. You have just been officially and legally caught in the act of adultery. But this is not a genuine scandal, and this is not a betrayal of your vows. This is a carefully choreographed legal theater, a highly orchestrated and staged production that just cost you a significant portion of your life savings to arrange. Why would a rational, law-abiding man subject himself to this humiliating charade? Because in 1960s America, if you were a man who simply wanted to end a fundamentally broken, emotionally dead, or even abusive marriage, the legal system gave you absolutely no clean, dignified way out. You could not simply stand before a judge and state that you and your spouse had grown irreparably apart. The concept of mutual incompatibility did not legally exist. To get a divorce, you had to be a villain. You had to provide your state's court system with severe legal grounds, and in highly populated places like New York, the only universally accepted ground for an absolute divorce was adultery. This specific era, so often romanticized in popular culture through the nostalgic lens of immaculate suburban lawns, pristine nuclear families, and the sharp-suited stoicism of the mid-century corporate generation, actually harbored a dark, restrictive, and deeply punitive legal underworld. For men operating within the cultural parameters of the 1960s, marriage was an ironclad, state-enforced contract maintained by a judicial apparatus that aggressively refused to acknowledge mutual unhappiness. To dissolve the union, someone had to take the fall, and the societal mechanics of the time almost always dictated that the man shoulder the burden of absolute fault. This was done either to protect the social standing and reputation of the wife, or to simply expedite an otherwise impossible legal gridlock. This extreme legal rigidity led directly to the rampant, unspoken open secret of migratory divorces and widespread collusive perjury. Wealthy men would establish temporary, highly scrutinized 6-week residencies in Reno, Nevada, enduring the isolation of the desert just to access slightly more lenient divorce statutes. Those who could not afford the substantial financial drain of the Reno cure resorted to the aforementioned hotel room raids, deliberately fabricating false evidence of infidelity, extreme physical cruelty, or total abandonment. Think deeply about the psychological toll and the immense, crushing financial leverage this fault-based system created. We are analyzing a historical period where the very concept of no-fault divorce did not exist anywhere in the United States until California radically introduced it at the very end of the decade, in late 1969. For the entirety of the 1960s, a man stepping into a courtroom to dissolve his marriage was stepping onto a highly adversarial battlefield where his fundamental character, his hard-earned assets, and his future relationship with his children were completely contingent on proving, or silently accepting, severe legal fault. If a wife chose to contest the divorce, she could effectively hold him legally hostage in perpetuity. If she recognized her leverage, the financial extortion demanded in exchange for an uncontested divorce, often referred to quietly in law offices as buying your freedom, could completely and permanently decimate a man's financial future. Furthermore, in the corporate world of the 1960s, a man's marital status was intimately and permanently tied to his career trajectory and his perceived reliability by corporate boards. Corporations strongly preferred the stable, predictable married family man. A divorce was not just viewed as a private personal failure, It was a massive professional liability, a glaring red flag to upper management that indicated a dangerous lack of personal control or moral fortitude. Therefore, men were highly motivated to keep the legal proceedings as quiet as humanly possible, which perversely handed even more unchecked leverage to a spouse willing to create a public spectacle or drag the proceedings through open court. The societal expectation was absolute. The man, designated as the sole head of the household, had failed in his primary duty to maintain domestic order, regardless of the private, nuanced realities of the domestic sphere. We are looking at a decade where the concept of mental health, emotional compatibility, or even basic human happiness were considered entirely irrelevant by the judicial system. The law only recognized tangible, provable, dramatic destruction. This rigid, unforgiving framework forced countless men to endure decades of silent misery, internalizing their despair in commuter trains and isolated urban living rooms, simply because the legal and social cost of pulling the ripcord was catastrophic. And for those who did attempt to break free, the financial devastation was often absolute. Alimony in the 1960s was not merely a temporary tool for transitional support, as it is often framed in modern discussions. It was explicitly designed to be punitive. It was a lifelong financial pension awarded to the legally designated innocent spouse, funded entirely and indefinitely by the guilty spouse. If a man accepted the legal fault to secure the physical divorce, he was simultaneously signing a lifetime financial indenture. Compounding this financial ruin was the era's strict adherence to the tender years doctrine. This was an embedded legal and cultural presumption that children, particularly those under the age of adolescence, inherently and naturally belonged exclusively with their mothers. For a father in the 1960s, a divorce almost universally meant immediately becoming a marginalized weekend visitor in his own children's lives, assuming he was fortunate enough to be granted any visitation at all. He was legally and culturally reduced to a mere paycheck, expected to bear the absolute brunt of permanent alimony and child support, while simultaneously being entirely stripped of his paternal authority and daily presence in the family structure. The courts viewed the divorced man strictly as a provider, a financial utility whose primary purpose was funding the separate household of his former spouse, regardless of the underlying reasons behind the marital collapse. But here is the most critical question, the historical open loop that you absolutely must understand to navigate the realities of the modern world. How did a legal system rooted in extreme puritanical fault, staged hotel room raids, and the strict biological biases of the tender years doctrine mutate into the complex family court infrastructure we see operating today? Did the introduction of no-fault divorce actually liberate men, or did it simply strip away their ability to defend their assets against a spouse who could now legally leave for any reason, at any time, while still demanding the exact same financial spoils of the 1960s breadwinner paradigm? The modern legal landscape that American men face right now, today, is completely incomprehensible without a surgical, objective dissection of the 1960s divorce culture. You cannot possibly understand the current systemic biases, the immense financial risks, and the grueling custodial uphill battles without realizing that the ghost of the 1960s family court still haunts the architecture of every single modern proceeding. The primary disadvantage many men face today is a severe lack of historical context. They walk into high-stakes negotiations or intimidating courtrooms falsely believing the system operates on pure, objective logic or contemporary ideals of absolute equality. They are entirely blind to the residual systemic architectures that were originally designed to enforce a 1960s model of family economics upon a vastly different modern reality. In this deep dive analysis, we are going to completely dismantle that historical ignorance. By rigorously examining the historical trends, the restrictive mid-century statutes, and the precise legal shifts that occurred during this turbulent decade, you will gain a profound strategic advantage. We are going to address the critical vulnerability of systemic blindness. You will learn exactly how the legal precedents established during the rigid era of fault-based divorce laid the permanent groundwork for modern alimony debates and asset division strategies. You will see the exact legislative turning points that shifted the burden of proof, and how the cultural perception of the divorced man evolved from a heavily stigmatized social pariah to a primary target of aggressive financial redistribution. This analysis is not about lamenting the past. This is entirely about arming yourself with critical knowledge for the present. By analyzing the extreme case studies of men who navigated the Reno divorce mills and the high-stakes, ruinous financial settlements of the mid-20th century, you will uncover the underlying hidden mechanics of family law negotiation. You will understand precisely why modern courts still default to specific, predictable patterns regarding asset distribution and child custody. This comprehensive deep dive will provide you with the contextual armor necessary to accurately anticipate potential outcomes in the modern legal arena. You will no longer view family law as a series of arbitrary, unpredictable rulings. You will see it clearly as a highly predictable machine built directly from the remnants of 1960s cultural expectations. By mastering this historical blueprint, you empower yourself to make highly informed, calculated, and strategic decisions to protect your assets, assert your paternal rights, and secure your future in an otherwise unpredictable legal landscape. To truly grasp the magnitude of this shift, we must first completely strip away our modern sensibilities. Sitting here in the year 2026, the concept of a mutual, amicable split is practically a default assumption in our cultural vernacular, even if the reality is often much messier. We are conditioned by decades of legal reform to believe that if two adults are deeply unhappy, they simply file the necessary administrative paperwork, divide the marital assets according to standardized state formulas, and walk away to begin their lives anew. But let us construct an imaginative scenario to vividly illustrate the sheer, terrifying claustrophobia of the mid-century legal apparatus. Imagine if you are a man named Thomas, a 35-year-old civil engineer living in a rapidly expanding, middle-class suburb of Boston in the year 1964. You provide a highly comfortable life for your family, your 30-year mortgage is paid on time every single month, and you are a respected member of your local community. Behind closed doors, however, your marriage has devolved into a freezing, silent wasteland of mutual resentment and deep psychological alienation. There is no physical abuse, there is no dramatic, headline-grabbing infidelity, and there is no catastrophic financial ruin threatening the household. There is simply a profound, suffocating incompatibility that has steadily eroded your mental health and your spirit over the course of a long, agonizing decade. In our current landscape of 2026, Thomas would quietly consult a local family law attorney, file a standard petition citing irreconcilable differences, and begin the grueling but highly structured process of untangling his life from his spouse. But in 1964 Massachusetts, Thomas has absolutely no legitimate legal recourse whatsoever. The state government at this time views his marriage not as a private, interpersonal relationship subject to the shifting emotions of the individuals involved, but as a rigid, unyielding civic institution essential to the structural integrity of American society. The courts simply do not care if Thomas is severely depressed. They do not care if his wife is equally miserable and unfulfilled. Unless Thomas can legally prove, beyond a reasonable shadow of a doubt in a public forum, that a severe, socially condemned statutory offense has been committed, he is legally trapped in that suburban house until the day he dies. This is the brutal, uncompromising reality of the strict fault-based divorce system, a regime where the state actively forced its citizens to remain legally bound to their spouses, unless a specific, highly destructive crime could be thoroughly documented and exposed in open court. If Thomas decides he simply cannot endure another 30 years of this silent misery, he is forced to become an active, willing participant in an elaborate, highly illegal, and culturally accepted system of mass perjury. Because simple unhappiness or mutual incompatibility was never recognized as a legal ground for dissolving a marriage, ordinary couples across the United States were routinely forced to manufacture crimes to satisfy the strict puritanical demands of the judiciary. This is precisely where we see the historical trends of the collusive divorce explode into a massive, unregulated shadow industry in the early 1960s. Thomas and his wife, if both are genuinely desperate to escape the union, must sit down in a dimly lit, wood-paneled law office and meticulously plan out a completely fake narrative of extreme mental cruelty, physical desertion, or fabricated adultery. They are essentially conspiring to commit blatant fraud against the state court system, an act that carried severe, life-altering legal penalties if they were actually investigated and discovered. But the reality was that the judges, the opposing lawyers, and the court clerks all knew exactly what was happening on a daily basis. It was a massive open secret, a grotesque, formalized theater of the absurd where a fundamentally decent man had to stand before a powerful judge and falsely confess to abandoning his family or engaging in severe moral turpitude, permanently destroying his own social reputation, simply to obtain a basic legal decree of separation. Let us look at specific historical case studies of the era to understand the immense, terrifying power this framework gave to a spouse who felt slighted or vindictive. Suppose Thomas' wife suddenly decides she does not want to grant him this collusive, quietly arranged divorce. Perhaps she deeply fears the crushing social stigma of being labeled a divorcee, which in the tightly knit communities of the 1960s was a profoundly isolating status that almost inevitably resulted in being permanently ostracized from neighborhood associations, church groups, and established social circles. If she refuses to play along with the manufactured fault narrative, Thomas is completely and totally paralyzed. He absolutely cannot divorce her against her will without actual, provable fault. This dynamic gave wives in the 1960s an extraordinary, almost incomprehensible level of unilateral leverage over their husband's financial stability and personal futures. If Thomas desperately wanted out, and his wife firmly held the only keys to his legal freedom, she could demand an absolutely extortionate price for her legal cooperation. This practice of financial hostage-taking was so common, it was permanently woven into the fabric of mid-century legal strategy. A man would essentially have to buy his way out of his own life by surrendering everything he had ever worked for. We are looking at documented historical case studies where men willingly signed over the entirety of their corporate pensions, the full equity of their primary residences, and legally agreed to pay an astonishing 70 or 80% of their net income in permanent, lifelong, unmodifiable alimony, just to convince their wives to sign the uncontested fault-based divorce petition. The only viable alternative to this localized domestic extortion was the infamous migratory divorce, a bizarre legal phenomenon that created entirely new, booming microeconomies in places like Reno, Nevada, and later, across the border in Ciudad Juarez, Mexico. The state of Nevada had aggressively lowered its legal residency requirements to a mere 6 weeks, specifically and intentionally to attract the massive, highly lucrative wave of miserable, affluent couples seeking a legal escape hatch that their strict home states violently denied them. But we must analyze this route from the realistic perspective of a working man in 1960s corporate America. The legendary Reno cure was primarily accessible only to the extremely wealthy, or more specifically, to the wives of the wealthy who did not have to report to a demanding corporate office every single morning. If a working man like Thomas, our mid-level civil engineer, needed to establish a 6-week residency in a Nevada boarding house to obtain a divorce decree, he would be forced to completely abandon his career. In the rigid, conformity-driven corporate culture of the 1960s, a 6-week unexplained absence to procure a scandalous out-of-state divorce was an immediate, unrecoverable career death sentence. You would return to your home state of Massachusetts only to find your desk completely cleared out and your hard-earned professional reputation in permanent ashes. Major corporations of the era viewed a man's divorce as a sign of critical, dangerous instability. It was heavily judged as a severe moral failing that clearly indicated a man could not manage his own domestic household, and therefore, could absolutely not be trusted to manage important company assets, lead teams of personnel, or represent the corporate brand to the public. Therefore, the vast majority of working and middle-class men in America were completely and utterly cut off from these migratory escape routes. They were heavily trapped within their own home jurisdictions, forced to navigate the punishing, expensive gauntlet of local fault laws without any leverage. This incredibly restrictive environment naturally cultivated a highly predatory ecosystem of private investigators, shadow attorneys, and professional witnesses who made their entire living orchestrating the exact, humiliating hotel room raids we discussed previously. The severe financial drain of hiring these underworld fixers, combined with the catastrophic, permanent alimony settlements demanded by the fault system, meant that a man emerging from a divorce proceeding in 1965 was almost universally financially annihilated. He was rapidly reduced to a transient ghost in his own life, often forced into renting a single, dismal room in a local boarding house while working 50 or 60 hours a week simply to fund the comfortable suburban lifestyle of a family he was no longer legally permitted to be a part of. The deep psychological devastation of this inescapable reality cannot be overstated or exaggerated. Millions of American men were systematically stripped of their hard-earned assets, their local social standing, and their basic human dignity by a rigid legal system that viewed them strictly as defective financial utilities, machines to be discarded and aggressively drained of resources the moment the marital contract fractured. But the absolute most crushing blow of this era, the specific element of the 1960s divorce infrastructure that permanently broke the spirit of countless men and forever altered the fabric of American fatherhood, was not the devastating loss of the family house, and it was not even the soul-crushing burden of lifelong alimony. It was the absolute state-sanctioned severance of their paternal bond. We must thoroughly examine the terrifying power of the tender years doctrine, an invisible but deeply embedded legal mandate that aggressively dictated almost every single custody decision of the mid-20th century, and discover how its destructive biased legacy is still actively weaponized against fathers in modern courtrooms today. What exactly happened to a man's relationship with his children when the judge finally banged the gavel in 1966? And how did this specific unforgiving era invent the tragic, isolated concept of the weekend dad? To understand the absolute devastation of paternal rights during this era, we must conduct a forensic examination of the tender years doctrine. This was not merely a cultural bias or a gentle suggestion made to the judiciary. It was a rigidly enforced, practically insurmountable legal presumption that dominated American family courts. The doctrine mandated that children, particularly those in their formative years, inherently and biologically belonged with their mothers. The courts operated on the strict, unyielding assumption that a woman possessed an innate, mystical capacity for nurturing that a man was biologically incapable of matching. A father in the 1960s was legally defined not as a caregiver, not as an emotional anchor, but exclusively as a financial provider. His value to his children was calculated entirely in dollars and cents, by his ability to maintain the primary household from a state-mandated distance. A father could successfully prove that the mother was completely legally unfit, a process so brutal and destructive we will analyze it shortly. He had absolutely zero chance of retaining primary physical custody or even equal parenting time. Let us explore an imagine-if scenario to make this historical legal framework painfully clear. Imagine if you are a man named William, a 40-year-old mid-level manager living in a suburb of Chicago in the year 1966. You are deeply involved in your children's lives. You coach their youth sports teams, you help them with their mathematics homework every evening at the dining room table, and you are their primary source of emotional stability in an otherwise turbulent household. Your marriage collapses under the weight of mutual incompatibility, and you are forced through the grueling machinery of a fault-based divorce. You walk into that courtroom believing that your undeniable track record as a devoted, hands-on father will surely matter to the judge. You are entirely wrong. When the gavel falls, the judge applies the tender years doctrine without a second thought. Despite your deep bond with your children, the state legally evicts you from their daily lives. You are granted what the court refers to as standard visitation, a deeply isolating legal construct that officially invents the tragic archetype of the weekend dad. Suddenly, your entire relationship with your children is violently compressed into 4 days a month. You are allowed to see them every other weekend, picking them up on Friday evening and returning them on Sunday afternoon. You transition from being a central daily figure in their development to a marginalized visitor operating out of a cramped, rented apartment. Because the financial extraction of the 1960s divorce left most men with severely depleted resources, William cannot afford a secondary home that accommodates his children comfortably. His parenting time is reduced to entertaining them in public parks, taking them to local diners, and trying desperately to maintain a meaningful connection in an artificial time-limited vacuum. The system forced fathers to become mere entertainers rather than actual parents, establishing a devastating historical trend where men desperately tried to buy their children's affection during their brief visitation windows because they were legally stripped of the ability to parent them through daily discipline, routine, and natural presence. The psychological toll of this state-sanctioned alienation was catastrophic. Men were entirely cut off from the daily rhythms of their children's lives. They missed the small triumphs, the daily struggles, and the quiet moments that build the foundation of a parent and child bond. Furthermore, the court maintained a brutal financial paradox. While legally asserting that William was too biologically inept to raise his own children, the state simultaneously demanded that he hand over a massive percentage of his gross income to fund their lives in his absence. He was expected to quietly absorb the immense emotional trauma of losing his family, move into a smaller residence, and continue working tirelessly to support a household where his authority had been completely legally abolished. If he fell behind on these payments, he faced severe punitive measures, including the potential for incarceration, all while having absolutely no legal mechanism to demand more time with his children. But what if William refused to accept this fate? What if he decided to fight the tender years doctrine and fight for full custody? To even have a fractional chance of winning, the 1960s legal system required him to declare total war on the mother of his children. Because the presumption of maternal custody was absolute, the only way to override it was to prove to the court that the mother was critically and legally unfit. This did not mean proving she was a slightly flawed parent, or that William was simply better suited for the role. Proving unfitness in the 1960s required demonstrating severe, publicly destructive behavior. William would be forced to hire aggressive private investigators to stalk his estranged wife, desperately searching for evidence of severe moral turpitude, chronic alcoholism, or severe, documented mental illness that required institutionalization. He would have to take this gathered evidence and present it in open court, creating a permanent, highly public record of his wife's deepest failures and vulnerabilities. This adversarial system practically guaranteed the total psychological destruction of the family unit. In order to save his relationship with his children, a man had to completely destroy their mother in a public forum, creating a toxic, hateful aftermath that the children would inevitably have to navigate for the rest of their lives. The courts actively incentivized maximum conflict, forcing men to choose between losing their children quietly or destroying their ex-spouses publicly. Most men, lacking the immense financial resources required for this level of private espionage and aggressive litigation, and unwilling to subject their children to a vicious public spectacle, simply surrendered. They accepted their role as marginalized visitors and silent financiers, internalizing an immense, unspoken grief that defined an entire generation of American fathers. You must deeply internalize this specific history when observing the family court dynamics of the year 2026. The modern system did not just magically appear out of thin air. It was built directly on top of the legislative bedrock of the 1960s. While modern statutes now explicitly use language like the best interest of the child and formally claim to be gender neutral, the heavy, lingering momentum of the tender years doctrine still casts a massive shadow over negotiations and judicial discretions today. Many men walking into modern custody battles fail to realize that the cultural default setting of the American legal system, a setting reinforced for over a century, is maternal preference. Understanding the extreme historical baseline of the 1960s allows you to see precisely why equal shared parenting is still a heavily contested battleground in many jurisdictions, rather than an automatic, presumed right. By the late 1960s, the intense, suffocating pressure cooker of this fault-based bias system was reaching a critical breaking point. The courts were severely backlogged with collusive perjury, men were being financially annihilated, and the cultural shifts of the era were beginning to openly question the rigid, state-enforced morality of the past. A massive legal revolution was brewing on the horizon, one that promised to completely dismantle the theatrical hotel room raids, eliminate the need for fabricated fault, and finally allow individuals to exit broken marriages with dignity. In 1969, a radical new legislative concept emerged, heralded as the ultimate liberation for trapped spouses everywhere. But as this new legal machinery was deployed across the country, a terrifying new reality began to unfold. Did the invention of no-fault divorce actually free American men from the punitive financial grip of the mid-century courts, or did it systematically strip away their absolute last line of legal defense, inadvertently creating the most efficient, legally streamlined wealth transfer system in the history of the United States? The answer to that terrifying question lies in the precise, mechanical execution of the California Family Law Act, signed into law in late 1969 by then-Governor Ronald Reagan. This piece of legislation was universally heralded by the media and legal scholars of the era as a massive, progressive leap forward. It was meticulously packaged and sold to the American public as a necessary humanitarian intervention, a legal modernization designed specifically to eliminate the rampant perjury, the staged hotel room raids, and the humiliating public spectacles that define the fault-based system. The explicit promise was that no-fault divorce would allow fundamentally broken marriages to be dissolved quietly, efficiently, and amicably, without forcing either party to be publicly branded as a villain. For countless men who were silently suffocating in deeply unhappy marriages, trapped by the terrifying prospect of lifelong financial ruin or public disgrace, the headlines out of California read like absolute liberation. It appeared, at least on the surface, that the state was finally stepping back and allowing adults to manage their own private lives. But beneath the utopian marketing and the lofty rhetoric of personal freedom, a devastating legal trap was being set, one that completely rewired the financial dynamics of the American family and laid the exact foundation for the massive, industrialized family court system we analyze today in the year 2026. To understand the sheer scale of this architectural shift, we must examine the specific mechanics of what no fault actually meant in a courtroom setting. Prior to 1969, marriage was treated by the state as a binding bilateral contract. In standard contract law, you cannot simply walk away from a legally binding agreement without facing a penalty, unless the other party has explicitly breached the terms of that contract. The fault system, for all its horrifying flaws, adhered to this basic principle. If you wanted out, you had to prove the other person breached the contract through adultery, cruelty, or abandonment. If you could not prove a breach, and the other person did not want to end the contract, you were permanently legally bound. The introduction of irreconcilable differences fundamentally destroyed this centuries-old legal baseline. It introduced the radical concept of unilateral divorce. Suddenly, for the very first time in American history, the state granted one party the absolute, unchallengeable power to terminate the marital contract at any time, for any reason, or for absolutely no reason at all, completely regardless of the other party's wishes. It required no proof of wrongdoing, no evidence of abuse, and no mutual consent. Let us use an imagine-if scenario to vividly demonstrate the catastrophic reality of this sudden shift. Imagine you are a man named Robert, a 45-year-old aerospace engineer living in the San Fernando Valley in the year 1971. You have spent the last 20 years working grueling hours to build a solid middle-class life. You have a beautiful home with a heavy mortgage, a healthy pension accruing at your company, and 3 children. You believe your marriage, while perhaps lacking the intense passion of its early years, is fundamentally stable and secure. One Tuesday evening you return from work, and your wife calmly informs you that she is completely unfulfilled, that she needs to find herself, and that she has filed for dissolution under the new California statutes. Under the old fault-based system of the 1960s, Robert would have possessed significant legal defensive leverage. If he had not committed any statutory crimes, his wife could not simply force a divorce and simultaneously demand his assets without his explicit, negotiated consent. He could have contested the filing, demanded a trial, and forced her to either prove extreme fault or walk away with absolutely nothing. But in the brand new legal landscape of 1971, Robert discovers he has been completely stripped of all legal agency. When he walks into the courthouse, he is utterly paralyzed to find that his behavior as a husband, his fierce loyalty to his family, and his flawless moral character are entirely inadmissible and completely irrelevant to the proceedings. The judge does not care that Robert was a dedicated provider, nor does the judge care that his wife is simply bored and looking for a change of pace. The state simply rubber stamps the unilateral dissolution. This is where the massive systemic wealth transfer mechanism is activated. The no-fault revolution successfully removed the requirement to prove guilt, but it completely failed to update the financial penalties that were originally designed for guilty parties. The courts aggressively maintained the traditional 1960s framework regarding alimony, child custody, and the division of property, but they now applied these devastating financial extractions without requiring any justification. Because California operated under community property laws, the state immediately mandated a strict mathematical division of everything Robert had built over 2 decades. His wife, despite unilaterally abandoning a perfectly functional marriage for purely subjective personal reasons, was legally guaranteed exactly 50% of the home equity, 50% of all savings, and a massive permanent claim on 50% of his future corporate pension. Furthermore, the deeply entrenched cultural biases of the 1960s had not miraculously vanished overnight. The tender years doctrine was still heavily implicitly enforced, meaning Robert's wife was practically guaranteed primary physical custody of their 3 children. As she now possessed the children, she was subsequently awarded the primary residence to maintain their stability, effectively evicting Robert from the home he paid for. And because Robert was still viewed strictly through the lens of the mid-century male provider role, the judge immediately ordered him to pay substantial, long-term spousal support and heavy child support. Robert was completely legally annihilated. He lost his daily access to his children, he was stripped of half his accumulated wealth, he was thrown out of his own house, and his future income was heavily garnished, all because the state now allowed his marital contract to be unilaterally shredded without cause. He was forced to endure the exact same financial and emotional devastation as a man convicted of severe, at-fault abuse in the 1960s, despite having done absolutely nothing wrong. The no-fault system did not liberate men. It completely disarmed them. It effectively weaponized the legal system, transforming the courts into highly efficient administrative processing centers that blindly redistributed male wealth, while actively shielding the initiating spouse from any financial or social consequences for breaking the family unit. This historical trend triggered an immediate, unprecedented explosion in the national divorce rate throughout the 1970s, as the overwhelming financial incentives for initiating a divorce became starkly apparent. The state had inadvertently created a highly lucrative environment where breaking a marriage was heavily subsidized and financially rewarded by the courts. Men across the United States were rapidly waking up to a terrifying new reality. Marriage was no longer a secure, legally protected partnership, but rather an incredibly high-risk, uninsurable financial vulnerability where their entire life's work could be legally confiscated at a moment's notice by a bored or dissatisfied spouse. But as this newly streamlined machine of unilateral divorce began processing millions of families, a massive macroeconomic storm was brewing on the horizon. What happens to this rigid, heavily biased system of alimony and child support when it violently collides with the catastrophic inflation of the late 1970s and the unprecedented, massive entry of women into the corporate workforce? Did the courts adjust their financial extractions to reflect this new reality of dual-income households, or did they aggressively double down, utilizing powerful new federal legislation to track, hunt, and extract resources from American fathers with a level of terrifying efficiency previously reserved only for tax evaders? The courts achieved this terrifying efficiency through a massive, unprecedented expansion of federal power that fundamentally altered the American legal landscape. As the no-fault divorce revolution swept across the country in the early 1970s, the national divorce rate completely exploded. Millions of established families fractured almost overnight, creating an immense, historically unprecedented wave of single-mother households. The United States government, staring down the barrel of a rapidly expanding welfare state and terrified of absorbing the catastrophic financial burden of these unilateral marital dissolutions, made a calculated, ruthless decision. Instead of recognizing the systemic failure of the no-fault experiment, the state turned its crosshairs directly onto the divorced father. The government realized that the absolute cheapest, most efficient way to manage the societal fallout of mass divorce was to forcibly extract the necessary capital directly from the male population. In 1975, the federal government quietly but decisively intervened in local state family law by passing Title 4D of the Social Security Act. This single piece of legislation completely transformed the relationship between a divorced American man and his government. It mandated the immediate creation of a massive, interconnected federal and state bureaucracy specifically designed to hunt down non-custodial parents, establish paternity through state mandates, and aggressively enforce child support and alimony orders. Before this federal intervention, local county courts had severely limited reach. If a man was financially suffocating under an impossible alimony order, he could potentially cross state lines to rebuild his life and escape the jurisdiction of a localized, biased judge. Title 4D completely destroyed that geographic shield. The federal government weaponized national tax records, centralized employment data, and interstate federal agencies to track divorced men relentlessly across the country. They built an inescapable, highly efficient financial dragnet that reduced the divorced father to a fully trackable, heavily monitored financial utility. Let us explore another imagine-if scenario to vividly understand the suffocating, inescapable pressure of this specific historical era. Imagine if you are a man named Richard, a 50-year-old factory foreman living in the industrial heartland of Ohio in the year 1976. You were unilaterally divorced a few years prior under the newly adopted no-fault statutes. At the time of your dissolution, the local judge applied the standard, outdated 1960s breadwinner formula to your settlement. You were ordered to pay a massive, fixed percentage of your gross income in permanent alimony and maximum child support. The court made this calculation based on the optimistic assumption that the American economy would remain relatively stable and that your industrial wages would steadily rise over time. But the macroeconomic reality of the late 1970s did not remain stable. It completely imploded. Richard is suddenly slammed by historical trends of unprecedented economic stagflation. The cost of basic human necessities like groceries, home heating oil, and gasoline triples almost overnight due to massive supply shocks and rampant inflation. His factory wages, eaten alive by double-digit inflation, barely cover his own survival in a cramped, unheated rented apartment. However, the family court system absolutely refuses to acknowledge this macroeconomic disaster. The judge views the court-ordered financial extractions not as flexible obligations tied to real-world economic survival, but as ironclad, immutable mandates. Furthermore, Richard encounters a brutal systemic paradox. His ex-wife has now enthusiastically entered the corporate workforce, riding the massive wave of cultural shifts and equal opportunity employment that defined the 1970s. She is generating her own independent income, taking advantage of new economic mobilities, and perhaps even matching or exceeding what Richard brings home from the struggling factory. In any logical, objective, or equitable system, this dramatic change in financial circumstances would trigger an immediate, mandatory reduction or total termination of the alimony and child support orders. But the courts during this transitional decade aggressively refused to adapt to reality. They maintained a punishing cognitive dissonance, publicly celebrating the new financial independence of women in the workforce while simultaneously and rigidly enforcing the outdated, parasitic financial extractions of the 1960s in private courtrooms. A man was still legally penalized and financially drained as if his ex-wife were entirely forbidden from entering the labor market. The courts essentially allowed the initiating spouse to double dip, retaining her fully subsidized 1960s homemaker financial package while simultaneously hoarding her newly acquired 1970s corporate salary, all entirely funded by the legally enforced impoverishment of the father. Richard is trapped in a completely unlivable mathematical nightmare. He is forced to fund his ex-wife's household at a comfortable standard of living that he himself can no longer afford, while she simultaneously accumulates her own protected wealth. When Richard inevitably falls behind on these mathematically impossible payments, the new federal enforcement machine activated by Title 4D descends upon him with terrifying, industrialized speed. He is not treated as a struggling citizen caught in a historic economic crisis. He is instantly and legally classified as a deadbeat, a criminal delinquent deliberately evading his state-mandated duties. The enforcement process is a methodical, step-by-step dismantling of his public reputation and private survival. First comes the automated wage garnishment. Imagine the profound professional humiliation when the Human Resources Department of Richard's factory is legally compelled by federal mandate to intercept his earnings. His private marital collapse is suddenly broadcast directly to his corporate superiors. The payroll department systematically strips away his income before the check is ever printed, leaving him with a legally mandated poverty wage that completely ignores the skyrocketing cost of his daily commute, his utilities, and his basic food requirements. Next, the state intercepts his modest tax refunds, siphoning away his only annual financial safety net. They suspend his driver's license, making it practically impossible and highly illegal for him to commute to the very job that funds the entire extraction operation. Finally, he is threatened with actual incarceration in modern debtor's prison, a medieval concept that was quietly resurrected, legally sanitized, and deployed under the guise of civil contempt of court. You must deeply recognize that this 1970s legislative architecture is the exact same foundation that powers the modern family court enforcement networks you see operating today in the year 2026. When a modern man expresses absolute shock that his wages can be garnished without a jury trial, or that his federal passport can be instantly revoked for falling behind on mathematically flawed temporary support calculations, he is experiencing the direct, unadulterated legacy of Title 4D. The sheer, uncompromising aggression of the modern collection apparatus is entirely inherited from this panic-driven 1970s federal mandate. It is a system that fundamentally views fathers not as necessary parents, not as human beings experiencing economic hardship, but entirely as highly reliable revenue streams meant to infinitely subsidize the chaotic aftermath of unilateral divorce. This deep historical context is your greatest strategic asset. Men walking into family courts today falsely believe they are dealing with a local, human judge making localized, empathetic decisions based on modern fairness. They fail to understand that they are actually stepping onto a highly industrialized conveyor belt, a federalized wealth distribution matrix that was heavily reinforced during the economic crises of the mid-20th century. The system was never designed to be fair. It was specifically engineered to be ruthlessly efficient at extracting resources from you, regardless of your personal survival. But as this massive, federally backed enforcement machine solidified its terrifying grip on the financial lives of millions of American men, an entirely new, incredibly toxic legal strategy began to emerge in the shadows of the late 1970s and early 1980s. With actual fault effectively removed as a requirement for divorce, and the financial extraction machine running at maximum automated capacity, vindictive spouses needed a brand new weapon to gain the ultimate, unquestionable upper hand in high-stakes custody battles and asset disputes. If they no longer needed to prove adultery or abandonment to secure the house, the children, and the lifetime alimony, what completely unprovable, socially devastating accusation could they fabricate out of thin air to guarantee total, instantaneous victory in a modern courtroom? The devastating answer to that question is the tactical deployment of the ex parte restraining order, a legal mechanism fueled by unverified allegations of domestic abuse or a strategically engineered perception of fear. As the legal landscape shifted into the late 1970s and 1980s, the no-fault divorce revolution had inadvertently created a massive power vacuum. Because the courts no longer required tangible proof of infidelity or cruelty to dissolve a marriage, the automatic, guaranteed unequal distribution of assets and absolute custody that defined the 1960s was suddenly, theoretically, up for debate. For a spouse seeking to utterly dominate the outcome of a dissolution, simply filing for a no-fault divorce was no longer sufficient. They needed a trump card, a fast-track method to bypass the slow, methodical process of equitable division and instantly seize control of the children, the property, and the narrative. This desperation birthed what became widely recognized in legal circles as the most destructive litigation tactic in modern family law history. To understand the sheer, terrifying power of this strategy, we must dissect the precise legal mechanics of an ex parte proceeding. In standard American jurisprudence, the foundational bedrock of the legal system is due process. If someone accuses you of a crime or a civil violation, you have the absolute constitutional right to face your accuser, examine the evidence against you, and present your defense before a judge makes a ruling. An ex parte hearing entirely suspends this fundamental constitutional right. It is an emergency proceeding where a judge hears only one side of the story, entirely behind closed doors, without the accused party even knowing the hearing is taking place. These emergency orders were originally designed with noble and necessary intentions, specifically to provide immediate, temporary protection for individuals facing genuine, imminent physical danger. However, in the high-stakes environment of family court, this protective shield was rapidly weaponized into a tactical sword. Because the standard of proof required to obtain a temporary ex parte restraining order is historically incredibly low, often requiring nothing more than a signed affidavit expressing a subjective feeling of fear, the system became highly susceptible to calculated manipulation. Let us explore a precise imagine-if scenario to illustrate the catastrophic efficiency of this tactic. Imagine you are a man named David, a 42-year-old high school principal living in the year 1984, whose exact legal nightmare continues to serve as the structural blueprint for cases happening right now in the year 2026. You are entirely unaware that your marriage is hurtling toward a cliff. One afternoon, while you are sitting in your office, two armed police officers enter your workplace. They do not ask you questions. They simply hand you a stack of legal documents and inform you that you are legally barred from returning to your own home, you are prohibited from contacting your wife, and you are forbidden from coming within 500 feet of your own children. In the span of 30 seconds, based entirely on a completely unverified, one-sided piece of paper, you have been instantly rendered homeless, publicly humiliated in front of your colleagues, and alienated from your family. David discovers that his wife, guided by aggressive legal counsel, filed for a temporary protective order simultaneously with her divorce petition. She did not need to provide medical records, police reports, or witness testimonies of actual violence. She merely needed to state to a judge that David yelled during an argument, or that she felt intimidated by his presence, or that she feared he might become unstable in the future. The judge, operating under extreme political and institutional pressure to err on the side of caution, rubber stamps the emergency order. This single administrative action completely dictates the entire future trajectory of the divorce. By securing the ex parte order, the wife achieves an instantaneous, absolute victory before the legal battle has even officially begun. She secures exclusive use and possession of the primary marital residence. She establishes de facto sole physical and legal custody of the children. And most devastatingly, she forces David into a desperate, defensive posture where he is presumed guilty by the court until he can financially bankrupt himself, proving his innocence. The true sinister genius of this historical trend lies in the concept of the legal status quo. David is told he will have a chance to defend himself at a formal hearing. But because family courts are notoriously backlogged, that hearing might not take place for 3, 4, or even 6 months. During this agonizing waiting period, David is living in a rented room, severely restricted from seeing his children, while continuing to pay the mortgage on the house he was evicted from. Meanwhile, his wife is establishing a brand new, court-recognized routine as the sole exclusive caregiver. When the court date finally arrives months later, let us assume David successfully proves that the allegations were entirely fabricated. The judge dismisses the restraining order, but the damage is already permanently locked into the system. The judge will look at the children and determine that they have grown accustomed to their new routine living exclusively with their mother. To minimize further disruption to the children, the judge will rule that the current living arrangement should become the permanent custody order. The temporary, fraudulently obtained status quo has successfully mutated into a permanent legal reality. David has been permanently reduced to a weekend visitor, effectively recreating the absolute worst outcomes of the 1960s tender years doctrine through a completely modern, insidious loophole. Furthermore, historical data and extensive case studies from this era reveal a terrifying lack of accountability regarding perjury in family court. If a man lied on a financial disclosure form to hide a bank account, he was aggressively prosecuted and faced severe punitive damages or jail time. However, if a spouse submitted a completely fabricated affidavit of fear to steal custody of children and secure the marital home, there was virtually zero historical precedent for criminal perjury charges. The courts consistently treated false allegations of abuse in divorce proceedings not as severe criminal fraud, but as mere tactical exaggerations. The judge would simply dismiss the protective order and move on to the asset division, completely ignoring the profound psychological trauma inflicted upon the father and the children. This absolute lack of legal consequences created a massive systemic incentive structure. There was absolutely no downside to attempting the silver bullet strategy, and the potential rewards were total absolute victory. This environment transformed the American family court into a theater of total war, fundamentally altering how men approached marriage and fatherhood. Men began to realize that their entire life, their relationship with their children, and their fundamental freedom could be instantly vaporized by a single whispered accusation. As we analyze the present realities of the year 2026, it is vital to understand that this specific tactical machinery has never been dismantled. Millions of men walking into family law disputes today are completely blind to the fact that their opposing counsel may be perfectly willing to deploy an unverified protective order, simply to gain leverage in a negotiation over a retirement account. But as this brutal tactic became normalized and millions of fathers were systematically evicted from their children's daily lives through administrative force, a much darker, long-term consequence began to surface in the American cultural landscape. What happens to the psychological and emotional development of a massive, unprecedented generation of children suddenly severed from their fathers? How did the psychological establishment define the devastating fallout of this forced separation? And what sinister multi-billion-dollar industry emerged from the shadows to actively profit off the endless, high-conflict litigation that these aggressive legal tactics guaranteed? The psychological fallout of this massive state-sanctioned father absence began to manifest in the early 1980s as a phenomenon that clinicians and sociologists eventually termed parental alienation. While the legal system was busy perfecting the administrative efficiency of asset redistribution and the tactical use of restraining orders, it completely ignored the catastrophic emotional architecture being built within the minds of the children caught in the middle. We must analyze how the 1960s legacy of maternal preference, when combined with the 1970s reality of unilateral divorce, created a vacuum where one parent could systematically erase the other from the child's psyche. This was not merely a side effect of divorce. It became a multi-billion-dollar industry fueled by a parasitic network of court-appointed evaluators, forensic psychologists, and high-conflict attorneys who realized that a quick, amicable settlement was a financial dead end for their practices. Let us explore a chilling imagine-if scenario to understand how this machinery operated on a human level. Imagine you are a man named Michael, a 38-year-old architect living in a quiet suburb of Atlanta in the year 1987. You have been fighting a grueling 3-year legal battle just to maintain basic visitation with your 7-year-old son. Following the standard historical trends of the era, your ex-wife was granted primary physical custody by a judge still clinging to mid-century biases. Over the course of those 3 years, a subtle but relentless psychological campaign has been waged against you. Your son, who once idolized you, now refuses to look you in the eye during the state-mandated alternating weekends. He repeats sophisticated, adult-level grievances that he couldn't possibly have formulated on his own. He tells you that he is afraid of you, though he cannot cite a single instance of why. He believes you abandoned the family, even though you were legally evicted by a sheriff's deputy following a false restraining order. Michael is witnessing the step-by-step psychological dismantling of his paternal bond. In the year 2026, we recognize this as a severe form of psychological abuse, but in the 1980s and 90s, the family court system was not only blind to it, they were actively profiting from it. Because Michael desperately wants to save his relationship with his son, the court orders a custody evaluation. This is where the shadow industry truly begins to extract its pound of flesh. Michael is forced to pay thousands of dollars to a court-appointed psychologist who has no actual accountability to the family. This evaluator spends a few hours interviewing the child, who has been carefully coached by the alienating parent to express fear or dislike of the father. The evaluator then produces a massive jargon-heavy report that the judge, who has no specialized psychological training, accepts as absolute gospel. The financial extraction in these cases is staggering. We are looking at historical case studies where men were forced to liquidate their remaining assets, including retirement accounts and college funds, just to pay for a revolving door of experts, guardians ad litem, and supervised visitation monitors. The system creates a pay-to-play model of fatherhood. If Michael cannot afford the next $5,000 psychological assessment, the court simply defaults to the mother's narrative. This created a perverse incentive for high-conflict attorneys to keep the fires of resentment burning. A peaceful resolution meant the billing stopped. An endless high-conflict battle over every single detail of the child's life, from which summer camp they attend to what time they are dropped off on Sundays, guaranteed a steady multi-year stream of revenue for the legal and psychological professionals involved. This era also saw the rise of the best interests of the child standard, a legal phrase that sounds inherently compassionate, but is, in reality, the most dangerous weapon in a judge's arsenal. Unlike the rigid laws of the 1960s, which were predictable in their unfairness, the best interest standard is entirely subjective. It grants a single judge nearly unlimited discretionary power to make life-altering decisions based on their own personal biases, their mood that day, or the persuasive power of a high-priced expert witness. For men like Michael, this meant that even if they followed every rule, paid every cent of support, and showed up for every minute of visitation, their rights could be stripped away at any moment if a judge simply felt that the conflict created by the mother's alienation made the father's presence too stressful for the child. The system effectively rewarded the alienating parent for creating conflict, using that very conflict as a justification to remove the father from the equation entirely to achieve peace. The data from this historical period began to show a terrifying correlation. As these millions of fathers were systematically marginalized, the United States began to see an unprecedented rise in every social pathology imaginable among the youth of the 1980s and 90s. Sociological case studies began to link father absence directly to increased rates of juvenile delinquency, substance abuse, and academic failure. Yet, the family court machine, now a massive self-sustaining bureaucracy, refused to pivot. The federal funding provided by Title 4D, which we discussed earlier, was tied to the collection of child support, not the enforcement of visitation or the protection of the paternal bond. The state had a direct financial interest in maintaining the status quo of the single-mother household because it maximized the flow of federal subsidies and collection fees. For the American man, the 1980s and 90s were a period of total tactical encirclement. He faced a legal system that allowed his marriage to be ended unilaterally, a federal government that tracked his every cent with satellite-age precision, and a psychological legal complex that could turn his own children against him for a fee. The social contract of the mid-century had been completely shredded. The 1960s man was expected to be a provider in exchange for a stable home and a recognized place at the head of the family. The late-century man was expected to be a provider while having no home, no authority, and no guarantee that he would even be allowed to speak to him. This brings us to a critical realization for anyone navigating the world of 2026. The modern father is not just fighting his ex-spouse, he is fighting a legacy of institutionalized profit. The family court system is a business, and high-conflict divorce is its primary product. When you understand that the experts, the evaluators, and the lawyers are all operating within an ecosystem that thrives on your continued litigation, you begin to see why the system is so resistant to reform. You begin to understand why common-sense solutions like mandatory 50-50 shared parenting are lobbied against so fiercely by bar associations across the country. They are protecting a revenue model that was perfected during the chaos of the post-1960s legal revolution. But as the new millennium approached, a new variable entered the equation, one that the architects of the family court system never anticipated. For decades, the system relied on the fact that these proceedings happened in the dark, in closed courtrooms, with men suffering in isolated silence. But the digital revolution was about to blow the doors off the courthouse. How did the rise of the internet and the sudden viral spread of legal information begin to dismantle the monopoly of the family court industry? And more importantly, as men began to organize and share the tactical secrets of the system, how did the courts respond to this new, informed resistance? Was the system finally forced to evolve toward genuine equity, or did it develop even more sophisticated, hidden methods to maintain its grip on the American father's future? The transition into the digital age did not initially result in a sweeping reform of the family court system. Instead, it triggered a massive, high-stakes arms race between the established legal bureaucracy and the newly informed public. As we sit here in 2026, it is easy to forget that for nearly 40 years, the specific mechanics of divorce law were a closely guarded guild secret. In the 1960s, if a man was being financially decimated by a biased judge, his only source of information was his own attorney, who was often a member of the same local bar association as the opposing counsel and the judge themselves. This closed-loop system ensured that men remained compliant, believing that their specific, punishing outcome was simply the unavoidable standard of the law. But the late 1990s and early 2000s saw the birth of the digital resistance, as men began to utilize early internet forums and bulletin boards to aggregate their experiences, share court transcripts, and expose the underlying financial incentives of the Title IV-D system. This sudden democratization of legal information was a direct threat to the multi-billion-dollar high-conflict industry. For the first time, a man in Florida could compare his case to a man in Washington and realize that the same forensic psychologists were using identical cookie-cutter templates to justify the removal of fathers from the home. They began to uncover the specific historical trends of how federal subsidies were being funneled into state coffers based on the volume of child support collected, creating a direct conflict of interest for the very judges presiding over their cases. This led to the rise of pro-se litigation, where men, exhausted by the endless billing cycles of attorneys who refused to fight for their paternal rights, began representing themselves. Imagine if you are a man named Steven, a 45-year-old software developer in the year 2005. You are navigating a divorce and you realize that your attorney is suggesting a settlement that effectively mimics the 1960s model. You lose the house, you lose 70% of your time with your children, and you pay permanent alimony. In 1965, Steven would have had no choice but to sign. In 2005, Steven goes online and discovers a community of thousands of men who have successfully challenged the constitutionality of these proceedings. He finds specific case law, he learns how to file his own motions, and he begins to record every interaction with the court-appointed evaluators. Steven is no longer a passive victim of the machine. He is a strategically informed participant. However, the system responded to this resistance with a sophisticated evolution of its own. As the public became more aware of the biases inherent in the tender years doctrine and the fault-based remnants of the 1960s, the courts pivoted to a more opaque, language-based defensive strategy. This is where we see the massive expansion of the best interests of the child standard into a virtually unchallengeable legal fortress. Because best interest is a subjective determination rather than a hard rule, it is remarkably resistant to digital exposure or statistical challenge. If a judge wants to maintain a 1960s-style custody arrangement in 2026, they no longer state that the mother is the natural nurturer. Instead, they use modern psychological terminology to claim that the father's work schedule or his living situation does not meet the specific, nebulous needs of the child at this particular developmental stage. This shift created a new, more expensive barrier to entry: the battle of the experts. In the 1960s, the bias was free of charge, it was simply the law. In the modern era, the bias is hidden behind a paywall of professional testimony. If Steven wants to prove he is an equal parent, he cannot just show he is a good father. He must hire his own $500 an hour forensic psychologist to counter the court-appointed evaluator's report. He must hire vocational experts to prove his ex-wife's earning capacity to mitigate alimony. The cost of achieving a fair outcome has skyrocketed, effectively pricing a significant portion of the American male population out of justice. We are seeing a historical trend where the legal system has successfully rebranded its old biases into a modern, professionalized service industry. Furthermore, we must analyze the emergence of the domestic violence industry as a primary driver of modern legal outcomes. While the 1960s required provable physical cruelty, the modern era has seen the definition of abuse expanded to include emotional distress, financial control, and even heated arguments. This expansion was documented in numerous case studies where the mere allegation of a non-physical offense became the primary lever for securing a 1960s-style tactical advantage. Under modern statutes, a man can be removed from his home and stripped of his children without a single bruise ever being documented. This is the ultimate refinement of the ex parte system we discussed in the previous part. The courts have effectively created a system where a man's constitutional rights are secondary to the administrative convenience of the protective order. As we look at the data in 2026, the consequences of this evolution are stark. We are seeing a massive decline in marriage rates among younger men who have witnessed the financial and emotional carnage of their fathers' and grandfathers' generations. They have analyzed the historical trends and concluded that the current legal contract of marriage is an asymmetric risk with no viable insurance. The system, in its greed to extract maximum resources from the 1960s through the early 2000s, may have inadvertently destroyed its own tax base by making the institution of marriage appear fundamentally radioactive to the modern male. But there is a final, even more complex layer to this deep dive. As men have pulled back from the traditional marital contract, the state has begun to experiment with new ways to attach financial liability to informal relationships. The ghost of the 1960s breadwinner model is now being applied to men who were never even married. We are entering the era of common law expansion and de facto parentage, where the state seeks to maintain its revenue streams even as the nuclear family dissolves. How are the courts in 2026 attempting to bridge the gap between a world that no longer wants to marry and a bureaucracy that still demands its 1960s-style extractions? What happens when the state decides that your live-in girlfriend of 3 years is now legally entitled to a portion of your 401k? Or when a judge decides that your role in a child's life, even if you are not the biological father, requires you to pay 18 years of support? The legal trap is no longer just for the married man. It is being expanded to cover the entire spectrum of male-female interactions. In the final parts of this masterclass, we will uncover the specific, hidden triggers of this new legal reality and provide you with the ultimate historical roadmap to navigating the most dangerous decade for men in American history. If you thought the 1960s were restrictive, you haven't seen how the modern system plans to handle the man who decides to walk away entirely. How does the machine respond when its primary source of fuel decides to stop playing the game? The response of the state apparatus to the declining marriage rate has been a quiet but aggressive expansion of the definition of legal responsibility. As we navigate the year 2026, we are witnessing the birth of a new legal frontier where the protections once afforded by remaining single are being systematically eroded. The system, having perfected the art of extracting resources from the 1960s nuclear family, is now recalibrating to extract those same resources from informal, cohabitating relationships. This is a historical trend fueled by the state's desperation to maintain the flow of federal Title IV funding in an era where fewer men are willing to sign a traditional marriage license. The courts are increasingly adopting the doctrine of de facto parentage and expanded alimony, effectively ensuring that even if you choose to avoid the altar, you cannot necessarily avoid the 1960s-style financial fallout. To understand this expansion, we must look at how the judicial system handles the concept of the psychological parent. In the mid-20th century, legal rights and obligations were almost exclusively tied to biological reality or formal adoption. If you were not the biological father and had not legally adopted a child, you generally had no standing in court, but you also had no financial liability. However, modern case studies show a radical shift. Imagine if you are a man named Jason, a 34-year-old project manager in the year 2026. You have been in a committed relationship with a woman for 4 years, and she has a young daughter from a previous relationship. You have never married this woman, and you have never legally adopted her child. You have, however, acted as a stable figure in the household, contributing to rent, attending school plays, and providing emotional support. If this relationship dissolves in the current legal climate, Jason may find himself facing a terrifying legal paradox. In some jurisdictions, the mother can petition the court to declare Jason a de facto parent. The court uses a multi-factor test to determine if Jason has formed a parental bond with the child. If the court decides that he has, Jason is suddenly granted the right to seek visitation, which sounds like a benefit. But the hidden edge of that sword is that with parental rights comes absolute parental obligation. Jason can be ordered to pay 18 years of child support for a child that is not biologically his, based entirely on the fact that he was a supportive partner during a 4-year window. The state has essentially decided that any man who steps into a provider role, even temporarily and without a contract, can be legally locked into that role for 2 decades. This is the ultimate evolution of the 1960s provider mandate. It is no longer a choice you make at a wedding. It is a trap you fall into by being a decent human being in a cohabitating relationship. Furthermore, we must analyze the expansion of common law principles into the realm of asset distribution for non-married couples. Historically, if you weren't married, your assets remained yours. But several states are moving toward a framework where long-term cohabitation triggers a presumptive division of property. If you have shared a residence and commingled finances for a specific period, a judge can rule that a constructive trust exists, allowing a partner to claim a percentage of your 401k, your home equity, or your business interests. The system is essentially imposing a marriage-like contract on men who explicitly chose to avoid that contract. The 1960s man was trapped by the law. The 2026 man is being trapped by his own lifestyle choices, as the state moves the goalposts of what constitutes a taxable domestic union. This brings us to the phenomenon of the administrative state versus the constitutional citizen. One of the most significant historical trends of the last decade has been the removal of these high-stakes decisions from the traditional courtroom and into the hands of administrative hearing officers. In many states, child support is no longer calculated by a judge who listens to your specific financial struggles. It is processed by an automated algorithm in a state agency. If your income drops because your industry is automated or your health fails, you don't get a day in court to explain. You are required to file a motion for modification, which can take months to process, all while the original debt continues to accrue interest at rates that would be considered usurious in any other sector of the economy. This is a form of digital indentured servitude, where a man's past earning capacity is used as a permanent benchmark for his future liabilities, regardless of the shifting realities of the modern labor market. The data from the early 2020s indicates that this level of systemic aggression has led to a dramatic increase in what sociologists call the underground economy. Men, realizing that any visible success will be immediately targeted by the family court machine, are choosing to downshift their careers, work for cash, or move to jurisdictions with lower extraction rates. They are opting out of the traditional ladder of success because the higher they climb, the more they have to lose in a system that lacks basic due process. This is the ultimate failure of the 1960s legacy. By making the cost of family failure so high and the definitions of family so broad, the state is actively disincentivizing men from participating in the economy at their full potential. But what happens when this resistance moves beyond just individual downshifting? We are seeing the rise of the sovereign individual movement and the use of complex legal trusts to shield assets from family court reach. Men are beginning to treat their personal lives like a corporate merger, using pre-cohabitation agreements and offshore asset protection to build walls that the 1960s-era judges cannot easily scale. However, for every new defensive wall men build, the state develops a new battering ram. We are now seeing the emergence of laws that allow judges to pierce these trusts or ignore these agreements if they are deemed unconscionable, a word that gives the court total subjective power to do whatever it wants in the name of equity. This masterclass has traced the journey of the American man from the staged hotel raids of 1962 to the algorithmic extractions of 2026. We have seen how the legal system evolved from a puritanical enforcer of morality into a cold, efficient machine of wealth redistribution. But there is one final crucial piece of this puzzle that we have yet to address. As the social contract between men, women, and the state continues to fray, what is the endgame? We are approaching a sociological tipping point where the number of men who have been processed through the family court system is reaching a critical mass. When a significant percentage of the male population views the state not as a protector, but as a predatory entity that stripped them of their children and their labor, the very foundations of social stability begin to crack. In the final part of this series, we will examine the potential future scenarios for the American legal landscape. Will the system finally collapse under its own weight as more men opt out of the workforce and the domestic sphere entirely? Or will we see a radical reform movement that finally introduces genuine, 50-50 shared parenting as the default starting point for all children, effectively ending the century-long reign of the tender years doctrine and the high-conflict industry? Most importantly, we will discuss the specific tactical steps that the modern man must take in 2026 to ensure that he never becomes just another case study in the history of state-sanctioned financial ruin. What is the one document more important than a prenuptial agreement? And why is the most dangerous person in your divorce not your ex-spouse, but the person you pay to represent you? The conclusion to this deep dive will provide the ultimate strategic clarity for surviving the most hostile legal environment in human history. To understand why the person you pay to represent you can often be more dangerous to your future than your actual spouse, we must examine the billable hour incentive structure that has remained virtually unchanged since the mid-1960s. In any other industry, efficiency is rewarded. In the world of family law, efficiency is a direct threat to a firm's bottom line. When a man enters a lawyer's office in 2026, He is often at his most vulnerable emotional state. He is looking for a protector, a gladiator who will fight for his children and his assets. The historical trends show that aggressive attorneys frequently exploit this vulnerability by stoking the fires of resentment. Instead of suggesting a collaborative, low-conflict mediation that could resolve the matter in weeks for a few $1,000s, they often push for an adversarial posture that guarantees years of litigation. Every motion filed, every heated email exchanged between counsels, and every discovery request for 10 years of bank statements is a meter running on your life savings. By the time the judge finally signs the decree, it is not uncommon for the legal fees on both sides to have consumed a significant portion of the equity in the marital home. The system is designed to transfer wealth from the family unit not just to the state, but to the legal guild itself. Let us explore a final imagine-if scenario to illustrate the ultimate strategic pivot required in 2026. Imagine you are a man named Christopher, a 50-year-old business owner who has spent the last decade watching the historical trends we have discussed. When his marriage begins to fail, Christopher does not rush to the most aggressive, high-priced litigator in the city. He understands that in the current legal climate, the court is a blunt instrument, not a scalpel. He recognizes that once you hand over control to a judge, you are subject to the best interests of the child standard, which we have already identified as a tool of total judicial subjectivity. Instead, Christopher adopts a stance of radical pragmatism. He understands that the most important document in his life is not a prenuptial agreement, which can be thrown out by a judge on a whim of unconscionability, but a comprehensive, privately negotiated settlement agreement reached before a single paper is filed in public court. Christopher's strategy is based on the realization that the only way to win in a system built on 1960s-era extraction is to refuse to enter the machine at all. He utilizes private mediation and collaborative law, where both parties and their attorneys sign a binding contract that if the matter goes to court, both attorneys must withdraw. This aligns the attorney's financial incentives with a resolution, rather than a conflict. Christopher is willing to concede on minor financial points to secure the one thing the state-sanctioned machine is least likely to give him: 50-50 shared and legal custody, clearly defined in a way that bypasses the tender years doctrine bias still prevalent in the judiciary. He understands that buying his peace and his paternal relationship up front is infinitely cheaper than trying to litigate for them later in a system that views his parenting time as a secondary concern to his provider status. However, even for the most prepared man, the legal landscape of 2026 contains hidden traps that can trigger the old 1960s-style ruin. We must look at the emerging concept of imputed income. This is a step-by-step process where a court decides you are capable of earning more than you currently do, and then sets your support obligations based on that hypothetical number. Imagine if Christopher decides to sell his high-stress business to spend more time with his children. The court can rule that he is underemployed and calculate his child support as if he were still running the company. This creates a state-enforced ceiling on a man's personal freedom and career flexibility. Once the machine has established your peak earning capacity, it expects that level of extraction indefinitely. Historical trends and case studies from the last 5 years show that judges are increasingly unwilling to allow men to downshift their lives if it results in a lower support check for the state-monitored household. This brings us to the endgame of the American family court evolution. We are approaching a moment of systemic friction. On one hand, we have an increasingly informed male population that is actively opting out of marriage and high-risk cohabitation. On the other hand, we have a massive, federally funded bureaucracy that requires a constant stream of high-earning fathers to remain solvent. This friction is resulting in the legislative creep we see in 2026, where the state attempts to attach the liabilities of the 1960s marriage contract to every informal relationship. The ultimate survival strategy for the modern man is not just legal, but foundational. It involves a total reassessment of asset ownership, the use of domestic asset protection trusts, and a commitment to maintaining a clean, documentable lifestyle that offers no foothold for the silver bullet strategy of fabricated allegations. As we conclude this deep dive masterclass, we must look at the potential for a grand realignment. There is a growing movement in several states to mandate equal shared parenting as the starting legal presumption for all divorces. This would effectively dismantle the century-long shadow of the tender years doctrine and remove the primary incentive for high-conflict custody battles. If the mother and father are both legally presumed to have 50% of the time from day one, the ability to use children as a financial or emotional bargaining chip is instantly neutralized. However, this reform faces massive opposition from the bar associations, and the psychological legal complex, as it would represent a catastrophic loss of revenue for the industry. The 1960s model is a cash cow that the legal system will not slaughter willingly. The historical arc from 1960 to 2026 reveals a system that has grown more sophisticated, more efficient, and more expensive, while remaining fundamentally rooted in a biased view of the male role. The man who succeeds in this environment is the one who treats family law as a high-stakes corporate negotiation, where the other side has the home court advantage. He is the man who understands that the law is not about justice, but about the administrative management of social outcomes and the preservation of state funding. By mastering the historical context of fault, no fault, and the federalization of enforcement, you gain the ability to see the traps before they are sprung. You realize that your greatest defense is not a better lawyer, but a life built with the foresight that the 1960s ghost is always in the room. We have covered the staged raids, the Reno cure, the no-fault trap, the Title IV dragnet, the weaponization of restraining orders, the profit-driven custody evaluations, and the expansion of liability to the unmarried man. This knowledge is your strategic shield. The 2026 legal landscape is a minefield, but it is one that has been mapped. The question remains: as the state continues to tighten the net on informal unions and imputed income, what will be the final breaking point for the American social contract? When the cost of participation in the family unit becomes so high that the majority of men simply refuse to play, the system will be forced into its final, most radical transformation. What does a society look like when the state can no longer find anyone to fund its 1960s-era dreams? The answer to that question will define the next 50 years of American culture, and it is a topic we are only just beginning to uncover as we analyze the rise of the opt-out generation and the total collapse of the traditional domestic incentive structure.